Great. So, morning, everybody. Kim Rademacher, Clinton van Nikkak from Rademacher Attorneys, and we are going to be talking to you today about plumbing. Is it your hobby or is it your business? Now, if it's your hobby, then there's no need to really listen to this talk. However, if it is your business and you want to make some money from it, then have a listen, and we'll guide you through a checklist of what it takes to have a business. So that's just our details in case you want to look us up as we go through the webinar, and just keep this in mind. You can send us email if you have some specific questions after the talk.
All right, so the title of the webinar is Plumbing, is it your hobby or is it your business? And it's very important to establish whether you want to pursue your trade as a business or if you're just doing it as a time filler. Once you understand what you want to get out of your trade, you can really achieve a lot more from your trade. So it's very important to establish exactly what it is that you want. So over the next few sessions that we hold, we'll be taking you through various aspects of business management that will assist you legally. So a lot of people ask, and in the trades in particular, why do you need to learn about the law? So it's important because every business has to operate within the confines of the law, and they must be able to protect themselves in terms of the law. You need to understand how to regulate your relationships with clients, and you also, importantly, need to know how to collect money from clients and what information is important for the purposes of collection.
So you might be saying, okay, great. So what does it take to have a business? And we've put up a 5-point checklist, which we will go into detail about shortly. However, we've identified these 5 that are appearing on the screen now. The first is to protect yourself by forming a separate legal entity. Clinton will take us through the different aspects of separate legal entity shortly. Secondly is to have terms and conditions of trading, and this goes to the heart of the importance of regulating client relationships. Thirdly, collecting payments, and this is probably one of the most important aspects, is obviously you need to have something in place to ensure that it is a smooth and hassle-free process. Fourthly, the Consumer Protection Act. It's a term that is bandied around by many people. How does it apply to you and what should you know? And number 5, keep proper records, i.e. keep a paper trail.
All right, so your forms of business enterprise, in general, you have 4 types. So as a business person, there are many ways to trade. Obviously, I would hazard a guess to say the vast majority of plumbers out there are trading as sole proprietors. There are also, so sole proprietors where you're trading just by yourself. It's you, there's nobody else. You might have some people working for you, but you're the business owner, and you're the one making all the decisions. A partnership is then just a group of people together who, it's very similar to a sole proprietor. It just means there's more than one person, and that you split the profits and all your costs. A closed corporation is then a separate legal entity. These can no longer be formed currently. So the last few are still out there. They can continue trading. A lot of them have already converted to private companies, but it's not a requirement to do so. But you can't open a closed corporation currently. And then obviously a private company, which is the most common form of separate legal entity where you are not a sole proprietor or a partnership. The main differences between these forms of ownership, the sole proprietor and the partnership, are very similar in that the sole proprietor and or partners are liable for all the debts of the business itself. So there's no separation between the debts of the business and the debts of the sole proprietor. So if the business incurs a huge amount of debt for something, let's say you do a job poorly and cause a huge amount of damage that has leads to a big claim against your business, that claim is against you as the sole proprietor personally. So it doesn't end up in a liquidation, it ends up in a sequestration, for instance. So there's no protection for the sole proprietor if things don't go right. Similarly with a partnership, if things don't go right, the partners can each bear personal liability for any of the claims against the partnership itself. That's where the closed corporation and private company bring their benefits. each of these has separate legal personality, which means that they are separate from the people who started them. So we won't really deal with closed corporations because we can't start those. In a private company, you have what are called directors and you have shareholders. So those shareholders are the people who started the business or somebody else who's bought shares in the company, and they do not bear any responsibility for the debts of the company. So the company may have assets to the value of 100,000 Rand. If there's a claim of R1,000,000 against the company, those people with the claim can only take the 100,000 from the company. They can't then take anything from you. You are protected in your personal capacity. It's only the company that takes the fall. And that's really why it's very important to understand the differences between the forms of business enterprise. And it's also important to start trading under the auspices of a private company rather than a sole proprietorship. It may be very easy to trade in terms of no formalities being in place if you want to be a sole proprietor, but at the end of the day, you're very well protected if you have a private company.
Then second on our checklist of having a business was terms and conditions for trading. And sometimes one doesn't want to put this together because you feel perhaps that your client may not wish to sign it, especially when you arrive with a terms and conditions document. However, questions to ask yourself: do you have a fixed rate for a call out? Is this call out rate different if it is an emergency or whether it is a routine call out? Do you have a document that your client signs as acceptance of what they need to pay you? Or do you just hope for the best that they will pay you when you have completed the work? So for us, if you have a simple terms and conditions document that the client accepts and signs, this will prevent disputes later. Perhaps having a simple document that sets out the work that you will undertake and what payment is will alleviate any disputes around the payment. We are very aware that when plumbers arrive to do a job, especially when there is an emergency, clients want you there as fast as possible. You undertake the job as best of your ability. And then when you present the bill, then they say, no, I didn't agree to that. And this is where these terms and conditions will go greatly to assist you in avoiding those kinds of disputes and having to prove what you did and what the client agreed to on the phone before you're arriving on site. And as we've indicated, have multiple copies ready to sign, ready to keep on your files, on your system to create that paper trail as part of your business, which we'll get to later. If you are interested in having terms and conditions for trading, please let us or our IOPSA know, and in conjunction with our IOPSA, we will be able to draft one for the plumbers to make use of.
All right, so this is one of the most important things for any business owner and one that people struggle with in general: collection of payments. This can be a very awkward topic when somebody owes you money and you don't really feel like giving them a call. So it's important to ask yourself a few questions. One of the important ones is, what systems do you have in place for collecting payments from clients when your job is completed? Obviously, as plumbers, your money comes from the service you provide. Once you've provided that service, you don't really have any leverage to claim payment from your client. You can't particularly claim back the car you just sold them or whatever the case is. You've given them the service and now you need to get your payment from them. That goes back to the terms and conditions for trading, obviously, because if you have terms and conditions in place, you do have at least a paper trail which allows you to refer back to at a later stage if you're collecting money from them through the legal route. So do you work on a cash only basis? And if so, do you issue receipts after collecting your cash? If you allow credit card payments in your business, do you have a portable credit card machine? And do you take it with you to go to site? If you work on an EFT system and your client doesn't pay you timeously, what is it that you do to follow up with your client to collect the money? Do you do nothing and just hope that they pay? Do you give them a call? Are you rude? Or these things must be taken into consideration. Sometimes it's awkward, so you come across as rude. You need to be able to handle these situations properly. You're fully entitled to place a call to your clients to ask them where your money is and to follow up with a letter requesting your money. There's nothing wrong with it. And I think that having the attitude that there is really nothing wrong with it will go a long way to alleviate your fears when you place those calls. In the event that no money is forthcoming, you can approach a debt collector to ask them to contact your client to request payment. And they'll obviously charge you a fee. Alternatively, there's obviously law firms like us where we can try and negotiate with the client for payment, and obviously we also charge a fee. So the best thing for you as a business owner is obviously not getting to the point where you need to have a debt collector or an attorney contact your client to get the payment, because obviously that's going to cost you some money. So the most important thing you need to know when you want to collect your money is that you need to have documentation in place that shows what you were charging your client and what work your client expected you to do. This goes back again to the terms and conditions for trading. Your terms and conditions are important because they set up the basis of your relationship with your client. They basically tell you, for instance, when you go to court, they show the magistrate or the judge, this is the document that regulated the relationship between me and my client. After they signed these terms and conditions, I gave them a quote. Even if the quote is via WhatsApp, it doesn't make a huge amount of difference. People trade nowadays by WhatsApp, they trade by email. It doesn't have to be a formal quotation on a piece of paper. If you send a WhatsApp and say, okay, my call out fee is 300 Rand an hour, to fix this, that, and the other thing, I'm going to charge you this much money. That is binding. If the person then says, yes, please come along, that is binding, and you can use that and you can rely on that at court. It's always important to have records in whatever form they might be. Okay, so as you can see on the screen in front of you, you must plan before you even take on clients. How is it that I'm going to get money from this client? Because if you have systems in place, you prevent painful collection processes later. So with a few simple documents, you can save yourself a lot of worry and time wasting. Those simple documents being your terms and conditions, your invoices, and specifically with regards to when you're performing repairs that require some replacements, delivery notes, and separating how much your labor costs from how much the parts cost. Those types of things are very important. Right. What is the Consumer Protection Act? Basically put, the Consumer Protection Act is a law that is designed to protect consumers, obviously, as the name would suggest. You as a service provider are subject to the Act, so it does apply to you, and it protects consumers from being treated unfairly by service providers. If you make certain that you always deal fairly with clients, the Act will not be much of a problem for you. But basically put, the Act aims to protect the consumer from unscrupulous conduct. It applies to all transactions unless the consumer, that's not you, that's your client, is a juristic person earning above a certain threshold, and the threshold at the moment is 2 million Rand a year. So the majority of your clients will probably not be juristic persons, and they'll probably not be earning above that threshold. So you are a service provider under the Act. One of the important things to remember is that where repairs are likely to be quite expensive, you do have a duty to tell the consumer first about what the cost might be and allow them to either accept the quoted costs or reject them. You can't proceed unless they accept the costs. So if you go ahead and you see that something drastic is wrong, and you know that it's going to be an expensive fix, and you just, without getting any confirmation, decide to replace or repair and undertake the work and then issue your invoice to the customer for a huge amount of money, they do have a leg to stand on if they complain about that kind of conduct. You need to inform them of those expensive repairs before you undertake them. As a simple rule, your policy should simply always be to seek approval before making any repairs or replacements. And as I said previously, it's very important for you to clearly distinguish between the amount you charge for parts and the amount you charge for labor. For instance, when somebody wants to return something to you, they can't return your labor's already been expended, so you don't have to refund them for the labor you used to install a part. But if you've installed a part and they haven't actually really used it and it can be used again, they can return the part for a refund, but they can't be refunded for the labor that you spent. There is a difference between the two, so it's always important to distinguish between them.
And then last but not least on our checklist is keep proper records. So I understand that generally speaking, plumbers do not have documents and folders and labels and all sorts of things that we as attorneys would necessarily have files for our clients. However, try and keep proper records at all times. This refers to proper accounting records and a paper trail in general. Keep the emails, keep the WhatsApps and the SMSs. You never know when you're going to need to refer to the arrangement between you and your client. not only to show the scope of work that you agreed upon, but also the rates that you are charging and why. Often a call out will come by WhatsApp or on the phone. Try and make a note of it in a notebook just to say what was agreed upon. Often people forget in an emergency what they agreed to. If the water is rushing through their house or there's a burst pipe in the garden, people won't necessarily think, oh yes, I agreed to pay the person that came to rectify the situation XYZ because it was such an emergency. Or at the end of the job, it took 3 hours instead of 2 hours. And again, they forget conveniently what you said that you were going to charge. So if you don't want to have a file for each client, consider having a lever arch file with an A to Z system where you can simply place documentation in an alphabetical order for future reference. These are very important. This is very important aspect of running a business. As we said earlier, you can then hand it over to your attorney to do collections for you. And also the paper trail will show that will show the, how should I say, the sequence of events that went through with you and your client to get to the point where you're at. You are required by law to keep paperwork and records for 5 years, so we're not being over the top in recommending this. So we have given you a very brief checklist for your business. Of course, there are many other items there that can be discussed. And if there's any particular item that you would like us to go into detail about, you may send us an email to info@rademeier.co.za. And if you have any questions relating to what we have explained today, please let us know and Sean will send them through to us now.
All right, 100%. Well done, guys. I have got one question here for you. I'll get right into it. It reads, if my terms and conditions state that all material belongings belong to me until fully paid for, can I remove them?
Okay, so we get this question quite often. The long and the short of it is no. You can't just remove it. You can't take the law into your own hands and just remove it. You can claim the goods back. So I'm not really sure how you would be proposing to remove it when it's in somebody else's home. If you've installed it in their home, removing it would require climbing over the fence at least, and that's definitely not okay. Basically, that kind of clause in your terms and conditions allows you to send a letter to your client and say, listen, you haven't paid. Based on the terms and conditions, I still own that piece of equipment. As such, if you don't pay within this amount of time, then I will be approaching court and we will be claiming it all back. Obviously, you'll be claiming the goods back plus any wear and tear that has occurred from their fair use of the piece of equipment. But no, you can't just take the law into your own hands and take it back yourself, unfortunately.
But it is, as Clinton says, should be in your terms and conditions because it allows you to take further action based on that condition.
All right, 100%. Well, then that is all of the questions I have got for you this morning. So would you like to end off from your side?
Yeah, just thanks for having us. We did have a good time and we hope to have many more.
Thank you. And anybody that needs us, just send us an email and we'll take it from there.
All right, 100%. Thanks so much for joining us, ladies and gentlemen. I do believe Kim and Clinton will be back next week to go over another one with you guys. But for this week, I am going to go ahead and end the session off now. Thanks so much for joining us. Please remember the survey on the way out and enjoy the rest of your week, guys. Thanks so much again. Bye-bye.
Thank you. Bye.